So Chairman Wontumi the new lawyer Samuel Atachia, Mobekaya ya de Bremo, na HSA or file application, they come out court, Ocha court no, and reschedule Chairman Wontumi the 3rd July judgment no. Omoma the time na on also emfa and court proceedings the muna and the court tenase or file its application no. Attorney General raise the objection say member court no and so a year. Chairman Wontumi the new lawyer if Samuel Atachia. So now court say hearing no ebekoso ene Monday. And the court na court na tenase no. Omutiti Chairman Wontumi the lawyer if Atachia omutiti na no ne nsem o keka no abusuan finally court no omo grant Chairman Wontumi the lawyer na application atum amasisi ano the 3rd July judgment no omo reschedule date no e dia pa 20th July 20th July na Ghana for only bit says ansem we no abusuan HSA answer too well with Ghana for cause ebi mo gidi pa say eye tactics and as a strategy bi na omo pese omo di delay court no judgment and proceedings na yedi kai aba be break bi e di amamo na no pay say court no boafu ama che say omo akoshin chairman Wontumi the lawyers on abuse of court proceedings according to Kevin Taylor yedi bremo na after say court no granted Chairman Wontumi the judgment and as an application no omo reschedule the date in the upper 20th no abusuya ensem bebre na ebobo e de free hoba enti no eno na ya project e de ato ye screen no enchen the amam no High Court grants Samuel Atachia's application to defer judgment for him to file his submissions. Court to deliver judgment on July 20th. Court to deliver judgment on July 20th. Abusuya empayimfo so ka bibi se sotra eben ono. Ayesa ojene ntem. The Chairman Wontumi ne lawyers yi na 20th July ne san so kokodru ha abusuya. She ni wa ebetumi etwetwa age Chairman Wontumi. Abusuya Kevin Taylor edin say ababe to damo me na yonko kuti na ye ba ye de akatum. So na san e ba na e be kono Ghana ha say open computer papa na laptop papa na we use abura perosi computers and accessories ho na obenya quality laptops na why then we using the location enya irapan o Kumasi Buokrom Estates Eli pick a number ya egu ye screen ya say na friend 0247030108 and I say 0597942133 mo mbonra yensem no mu e political highway so.
So that is what happened in court. Makacho said this document, if you want to get it, go to the court. It's there. These are court documents. Now let's come to what happened in court the day Apia Kubi. The day Apia Kubi called court. Eko kachre judge and say den onye lawyer to the Chairman Wontumi biom. Now you see this. Right now, you know the abetted say ochina attaching say oko in court. Didn't know court oko pray for 6 weeks. 6 weeks in any day. Or see a free be witness written submission or written addresses. Those submissions, no, you di asem we are. Lawyer bia odi client enim no. You will share your opinion on asem na utinemu a lawyer for somebody no. The accused lawyer etnim etro and I said the prosecution lawyer no. Now judge no really Apia could be case no that day no. Because that day na Apia could be called court so oko ka kire court say onye lawyer to Chairman Wontumi bi no. Judge ni tie ni nsem nyina no. Na Apia could be argument nyina no say judge no twentwen so. Because we you know free say onye Chairman Wontumi lawyer bi no. Chairman Wontumi ko fa another lawyer nti ma judge no emfa the judgment mba. Anything Apia could be called court that time. So the reason why Apia could be called court no. Nani nyina say okoka kire judge say menye Chairman Wontumi lawyer bi even though what date out of judgment ba no. Me Apia could be pesa wo twentwen wo judgment no so because mean enya me na me be tro written submission no media me ko obi na eba be tro. The question here is dey na judge ne ka that day na Apia Kubi eba court be ka say onye lawyer to Chairman Wontumi biom. Now in fact because on your loyalty written submission no judge remember from the judgment in back now because any on the better written submission or address that say lawyer for bar which is attaching on the better. But the question here is the written address and not submission from the lawyer after the case has ended, not judge actually judgment, does it really affect the case? In law, normal law, judge it's not kunjuma. So the phone way bar and no and a judge no esha hon edi buana asem. Say what the pen way bar and no and a judge no esha hon. Say accuse no the pen way bar no can say any evidence and no a judge no she. The judge is just looking at the pen. Now say accused no ed way bar no can say wait me evidence that the judge is just looking at this. Lawyers mienu a omudi accused and also whatever lawyers omo ho no the accused lawyer and our prosecution no the omo dwene efa asem no ho no their personal opinion which is the written address no at the end of the day is it an evidence about me affect the case nana. It is that two teams Abo and Ra. Croatia Ashe Ghana 2-1. Now, two teams no el filled in the Super Bowl. Your FIFA or manage the whole event. There's a referee in the middle of the game. Two assistant referees. They are match commissioners. Ball na ye no pitch this no. There are rules. Now, your ball ni wie. Ebia Ghana ne England the boy and Obian Shibi 0-0, right? There were some maybe a see or pitch na so. England goalkeeper na free in the boxing ebe tackles. On a normal day, FIFA rules, any game rules are a red card. The keeper left the demarcated zone also Odini Juma stepping out, whether he touched somebody or touch a ball cry at the end of the 2 yellow card and a red card. So Otumiko ball cry out of his box. Now and only coins also question or tackle be no be tough for ma. That ref keeper no so then sakabo then sankabo then sakanipa red card. That's how it is. Now Ghana saying another chance. Now omokoshe na in the box a defender a clamp Ghana a player down. Now we nya ball no because he needs to defend. He needs to clear that ball. Senenaya and ball no. Now the player who is attacking goes down in the box. It's a penalty. That's how the rules are. Now, Sanyama when you see your pitch so referee name, assistant referee so commissioner so yen you know FIFA president put to now you na referee no bar abem say 0-0. Whatever the coaches say at the press conference does not change the final score. After game, the coaches can meet the press 50 times. Whatever England coach Rebecca after the game, after the 90 minutes, plus other time, after the game, what matter? They see or pitch this their time within that 90 minutes and time added on. So 90 minutes, that is what the FIFA regulations recognizes. So Ghana coach Nico press conference 50, and then he speaks about how he's disappointed in the referee. Now it will not change the goal line, the goal scores, the score line. It will not change the point build up. So England coach no Kojina press conference 50. Now say Ghana coach journalists for Shannon can say, "Oh, Mr. Coach, how did you see the whole game? His opinion about the game, how his team played, how the opponents played, the tactics he played, how the opponent." It does not affect the final outcome of the game because the final outcome, the coach's ideas and opinions does not matter. The final, what matters is referee no decision no take here and the score line at the end of the day and the point everybody got. Our coach can express his views, and in law, the Atachia is a coach. Now in the middle of the game, FIFA himself. Brony we na coach. Na your ball game na mani bedu 80th minute. Na Brony nika se niyemu ya na ya. Na se o free pitch na so kofie. Na se another technical person ebe som se on na coach. That person's opinion on that game. Say upon game na sa coach no be take over from Ghana coach no. So in a press conference on to me say I don't want to accept the outcome of the game because I took over from our coach who wasn't feeling well at the 78th minute. It does not work like that. So, sa coach na obeji baton free the sick coach one obey coaching for the next 12 minutes or 22 minutes. You know, the issue here is FIFA does not care. The referee does not care. What the referee cares about is the game has been played. It's your point game, you know. Now your coach now obesomu from the 72nd minute, coach the 90th minute. Eka say he feels that he was not in charge of the game from day one, and so FIFA should reverse the points build up. FIFA should reverse the game for us to replay the game because time again they started on the Gina touchline. That is what Atachia is creating here. FIFA recognized the game that was started under the first coach. FIFA recognizes that Ghana had 11 players on the pitch. FIFA recognizes that there were referees refereeing the game. There were match commissioners. Whether you want to change your coach at the bench or not, it does not affect what FIFA, that 90 minutes, he has basically put together. Now, Atachia is saying, Onona ebe taking over from Apia could be at the 87th minute. Now, I cut 3 minutes. Yeah, the other time, Okrabe count. Emma obedru ya no krampo no na 90 minutes ni abowie. Emma referee the 3 added minutes account. Now see because oba no na yabo 90 minutes na wie no 3 other times so ono Atachia on recognize say a FIFA official time. Inti now no yensan go back and go start the game because sa 3 minutes na e does not go by no ono recognize sa 3 minutes no. This is what they are doing. And that is what Atachia is saying. Say he is going to court tomorrow, and that when he goes to court tomorrow, he's going to ask for 6 weeks. 6 weeks to do what? 6 weeks to write his submission. The question here is, your press conference will not change what happened on the pitch. Your press conference wasn't part of the rules. Your press conference, it is not what FIFA is looking at. FIFA is looking at what the referee basically at the end of the day saw as good or not. Inti Atachia right now is saying, say, now, wabano, sa game in a course, we should go back near for documents in Yamano. We have 6 weeks. Now, let me show you something. Now, this was the ruling I want all of us, and I've read this thing here about 3 times. Time Atachia, time Apia Kubi, Eko Kachire court to say, onye lawyer to Eyadi Chema Wontumi Bimno. He went there. Thank you very much, team. I will add this to it. I think did you add this? Did you send this before or you just sent this now? Now, time appear could be muka say or court kakache a court to say on person be chema Wontumi lawyer bimno. The judge said something to Apia Kubi. And it is very important because and no and I was a judge, you know, she or he needs to stick to. Now, yanko time Apia Kubi court kokache judge and say or no Apia Kubi no or nye chema Wontumi lawyer bim nemum Atachia and ebe chema Wontumi lawyer. Now, the judge said something that day during the ruling. Now, during the ruling of the judge, I have it. I'm trying to move it to the system. Thank you. During the ruling of the judge, you know, Okabibi, and no me pese ochna, the judge must, with all due respect to the judge, with all due respect, I believe the judge should or must stick to those principles. Because I have seen say MPP for any attach yamono, omo pese omu delay court no. They say they just want to delay the court. They just don't want the judgment to happen. And with all due respect to the judge, we want the judge to stick to principles because so far, judge na prove say or your honest judge and yet personal issues in no case in so. And yet obi no tano or pese obi that fair hearing. I believe say ochina before a judge no ebetie Atachia. Ghana for munim nyansa munim say asama yeken, we are basically speaking on the issues. The judge should first go back to his or her own hearing ruling. And no enebechre say sebio asama Atachia kano court or chinano etasuma na sentasum. Because with respect to Atachia asama deba, it's all about written submission. And we know the honorable judge or the case with he or she he has spoken or she has spoken on this witness written submission. Now let's do this before we go back to her ruling because Enona, with all due respect, we are putting out that the judge should consider her own ruling. Because if we sit in Ghana and we are in a country where Obia to a criminal case, now eka 2 weeks my judgment aba, now obey use this same precedent as a defense to fire their lawyer to get a new lawyer there, then no case will end in Ghana. Say, and the court not allow this kind of abuse. The court not allow it, Wontumi lawyers to abuse the court in this way. The issue here is a day will come. Nipe bi edit begina court. One, obe delay court na for 2 years. Now, it do 2 days. Now you betrone judgment. Obe catch Ghana for you say we changing a lawyer. Okachen say we there. I didn't know I say also imbrebi, and with law, it's all about precedents. Imbrebi Ghana law yet court ya. Nandi pebi wo court. Na aka 1 month my the judgment aba. Or say we changing the lawyer. Emma court to muma sebio yes static case. So this is a very dangerous path we are taking. And we are not supposed to allow Atachia to hide behind something called a written statement or written addresses. Now, written addresses now Atachia ko jina ho court or channel. What does it mean? Before I read judge, the ruling when appear could be ekoka so onye chema Wontumi lawyer biemu no. The judge na kasa faka ekafa written submission ho. The judge himself or himself on one case numa asema watra ewo record him. Now, let me show you this. The main legal basis written submission come from. Now, written submission any day, any case we na judge a lawyer and kasa say, me a lawyer to Kevin Taylor make share my opinion on the case. Any friend written submission. Now, a High Court of Civil Procedure Rules 2004 CI 47. This is what it says. In civil cases, the rules allow the court to direct parties to file written addresses submissions after evidence. It is therefore procedurally mandatory once the judge orders it. It is therefore, and this is in civil cases, the case we are faced with in court today, a criminal case. So in civil cases, any criminal cases, it is therefore procedurally mandatory once the judge orders for it. It is a civil case, say judge orders me per written submissions, that one you have to do it. And that only applies when it is civil cases. In civil cases, as I didn't see. Now, criminal procedure practices. So when it comes to civil cases, what happens is the civil procedure rules, which is 2004 CI 47. In civil cases, any criminal cases, Wontumi case were a criminal case. In civil cases, when the judge orders for written submission from the lawyers, it is an order and everybody has to put it in. Now we are looking at Wontumi's case, which is the criminal case. The distinction is very important. Criminal procedure practice. In criminal trials, there is no universal statutory requirement. In criminal trials, right now, Atachia or lawyer to Wontumi, he is trying to make it mandatory. This is a criminal trial. Written submissions are not mandatory, and the judge's ruling, she said it or he said it. But the reason to Atachia court or say he is a lawyer to Wontumi who is facing a criminal case, right? Now, the law actually say in criminal trials, there is no universal statutory requirement that written submission must always be filed. There is nowhere a criminal case, what we call written addresses must be filed. There is nothing like it always has to be filed. You can decide not to file it. Nobody cares. Because at the end of the day, it does not affect the evidence before the judge. That evidence, the judge, I call it the judgment. This is a criminal case. Now, when you read further, that's what it says. However, courts increasingly use them as part of fair and efficient trial management, especially in the complex or document-heavy cases. So, optional. It does not say it's mandatory. It's saying, no universal statutory requirement. It is not a must. Atachia, when he goes to court tomorrow and say, Judge, mommy, 6 weeks, I need to write my written state addresses. It is not mandatory. And the court is not supposed to grant it. Because without it, the judgment can still be read. So what Atachian is going to do tomorrow, our court in front of the judge, the judge herself or himself about 2 weeks ago made it clear her point. And I don't think, with all due respect to the judge, with all due respect, I don't think that judge will eat her own words back. Now, when you do a little bit of reading on this same judicial discretion, now, judicial discretion, and this was still under this 2004 CI 47, it says judges in Ghana have wide discretion to, 1, order written submission. Judges in Ghana have wide discretion. And we say judicial discretion, judges or on the decide. When you say discretion, send your wow pesa we ye. One kasa, Joma opese ekoso. And yamra and a show. So, your friend, judicial discretion. Judges in Ghana have wide discretion to order written submission. So, the judge could decide or can decide not to order for any written submission. 2, set timelines. The judge can decide not to set timelines and can decide to set timelines. 3, or proceed without them if unnecessary. The judge can go ahead and write their judgment without written submission, without the lawyer's opinion, without the lawyer's own understanding of the proceedings. The judge can still write their statement without even asking for any written submission. In fact, it is an option. It is not mandatory. What Atachia is trying to do, Atachia is trying to force the court to do something that is not mandatory. What is happening right now when it comes to written submission or addresses is optional. It is only in civil cases. And when a judge demands for it, even that one, the judge has to demand. In a civil matter, it is the judge who has to demand. But in criminal cases, no, it is optional. Now, let's go back to this same judge. When Apia Kubi echoed the Nimkoka and say, I don't want to be Chairman Wontumi lawyer again. And that Chairman Wontumi has a new lawyer. And that stop your judgment because Chairman Wontumi has appointed a new lawyer. What did the judge say? And let's be fair here. This is a judge for a long time. Wa accommodate the Chairman Wontumi. Wa accommodate all the things Apia Kubi. Now, it looks like Atachia wants to take over from Apia Kubi in this kind of cunning delayance when it comes to this criminal case. Now, let's go back quickly. I had now say pay all the attention. And it's about Judge Nankasa or no time Apia Kubi Bejina the Nimka say me lawyer match ma want to be they say Atachia never into delay with judgment. Then a judge we Ankasa kan. This is the same judge with respectfully. Ochina Atachia Eko Jana Nim say, or no Atachia demanding. Because at this point, Atachia is demanding. Atachia is telling the court that the court needs to do that. But in law, in Ghana's legal law, the issue is it is not mandatory in a criminal case for written submissions to be demanded. And I say, without written submissions, a judge cannot go ahead and pronounce judgment. No. Now, so we read Judge Nankasa ne Savio the ruling when it comes to day now Apia Kubi echo the nimna. In fact, let's read this one. They be me read this document where me de read and hono. Then a judge in the kind of timer Apia Kubi ko ne nim say onye Chairman Wontumi lawyer bim. Then a judge in the kind. This is the ruling from the judge. This is a few weeks ago. It's moment judge in the position on written submission. And sana ochina Atachia Eura court. Akokacha judge and say because of written submission, judge into judgment in shada. Let's see the judge in case when she was or he was ruling on that Apia Kubi issue. What did she say? What was her opinion, legal opinion on written addresses? Now, I'll say, consequently, since filing of closing addresses is optional, Tama na appear could be catch a judge and says, see, I mean, I want to be lawyer beam. Attachana Obano, says, Siano, or then a betro written addresses into a journey case, no judgment, no, to another date, send a judge the catch or see. Consequently, since filing of closing addresses is optional and not a function of the rules, that is to say, there is no provision under the rules compelling the lawyer for an accused or prosecution to file an address. According to say, addresses are optional statements made by lawyers. Listen, addresses, written addresses are optional statements made by lawyers to articulate on the merit or demerit on a case one way or the other. Or see, what we call written statements are optional. In fact, those written statements, they are done by lawyers to what? Tell people their opinion, to articulate their opinion about the whole game. It is like a press conference. Technically, written submission or addresses which lawyers write after cases are heard, evidence are provided. In criminal cases, they are optional. It is basically the opinion of the accused's lawyer or the defendant or the prosecution. At the end of the day, it's just an opinion they are expressing. This is like post-match interview, post-election interview. Written addresses are just court interview. It is the same as somebody going to court today. Appear could be court and then appear but not journalist able to question. It is basically daily written submission or addresses. Appear could be every day he walks out of court. He meets the press. That is the post court proceedings or press, his views, how he articulates, how he sees it. The merits and demerits. Oh, and the court, na be fine. And the moment the judge, I just want to that is his opinion. And that is the same thing here. It does not affect what actually transpired in court. The evidence that was put before the judge, the evidence that was put before the judge by the accused or the prosecution. No, it is just his opinion. That is why during this judge's ruling 2 or 3 weeks ago, he or she was clear that written addresses are post-court addresses. They don't affect what actually happened in court. They don't affect the evidence in court. It is the opinion of the lawyer. So the question here is, if it is just an option, it is the opinion of the lawyer, how can it affect the evidence put before the court? Because post-court reaction is done daily. Now, it is all the post-court reactions that you have seen from day one appear could be record opie ochena and no optionally he can decide to put all together in one big document and say this has been my opinion from day one. Every single day I share my opinion, but today I am going to put everything together. I'm going to summarize, compress it for people to know my opinion on the whole proceedings. So submissions or addresses by lawyers do not or cannot have an effect on judgment. Now, already judge in the last statement, or say the court would by this extend the time of filing written addresses from 17th of June to 24th of June 2026. For the avoidance of doubt, this matter is adjourned to 9 a.m. on the 3rd of July 2026 for the court to deliver judgment in this matter. Meaning, the judge herself or himself made it clear, I don't care about written addresses. I don't care about post-court addresses. What I care about is that I've given a date, and that date, the judgment will be read. And see, what I'm trying to say is, I'm just asking the judge, is she or is he going to eat their own word or his own words or her own words? Because we didn't know this until the judge sitting on that case told us that when a lawyer, after every single court case, walks out of court to share their opinion, is basically a written or oral written address. Now, the judge made it clear that those things are optional, not a function of the rule. When they say not a function of the rules, it means a court say without written submission or addresses, a judge cannot go ahead and pronounce judgment. No, that is the statement. That is the meaning. Inti, the question here is, Ochina, attaching echo court to say, young extended time, mano, all because of an optional written submission. At the end of the day, why should the court, with all due respect to the judge, at the end of the day, why should the court even hear Atachia out? Because so we read the judgment now. She even gave Atachia enough time to also write their submission. Now, when you read the last part of a judge ruling now, or say, the court will by this extend the time of filing written addresses from the 17th to the 24th, meaning the judge, nobody was compelling the judge to even extend the time of written submission. It's an option. If you want to write it, then I'm giving you time to write it. If you don't want to write it, I don't give a fuck about it. But a judge in her own wisdom, wanting people to say, at least I'm being transparent. I don't want people to say, oh, I did not even allow it because I'm not supposed to demand for written submission. It is not part of my judgment. The law does not compel the judge to say without written submissions from the lawyers, she cannot or he cannot bring out his judgment. So the question is, why did the judge even give him more? The judge was being more lenient from day one. Much now how they have abused the court. The court was being lenient to Chairman Wontumi and his lawyers. For the judge to even say, I've moved it from 17 to 24, the judge was even being lenient. The judge knows it is not important. But if it's for the optics, fine, I'll give you 24, write it and go and show it out. So from the 17th to the 24th, Atachia could not contact Apia Kubi. Atachia wants to tell me when Apia Kubi was handing over Chairman Wontumi's case to him, Apia Kubi didn't give him the proceedings of the court. Is that what Atachia wants to tell the judge tomorrow? When Atachia was given in room from 17th to 24th, Atachia came back to tell us that the registry did not give him the documentation. So you could see clearly that a plan, the same 442 formation, he wants to continue. It is the abuse of the court. So with me, or when you ask us, Loud Silence Media, my editorial team, we believe that the court should not even listen to Atachia. Because you see, let's be real, let's be real here with this matter. Say me a criminal case that me if I'm being accused, we are talking about Gift Owari is being accused of criminal things in Ghana. Obi to say a SkyTrain, a criminal case. We are talking about buffer stock, a criminal case. There are so many criminal cases at Air Court. The lawyers are watching. And with all due respect, I am talking to the judge. You yourself said that there are no rules binding you at the end of the day that without written submission, you cannot come out to your pronouncement, which is fine. We understand, we respect that. Now imagine all these smart lawyers are mere lawyers to these accused criminals, trial, and then what they are going to do is, if tomorrow, say judge way, knowing that written submissions are optional and not mandatory, and no law in Ghana in the legal framework is mandates any judge to say without written submissions, I cannot come out with my judgment. If tomorrow, say judge way 6 weeks, go and write her, what is going to happen is all the criminal cases we are seeing in court, and we are working with precedents here. This is legal field. We are talking about precedents. SkyTrain lawyers, Gift Owari lawyer, buffer stock lawyer, all the criminal cases in court today are oral. Lawyers. Remember, say judge way, with all due respect to the judge, Ochina decided to be granted Atachia 6 weeks. So uncle now Abra Odim say any mandatory from her own ruling. No, what is going to happen? And say, some cases when they will drag it. Now lawyers of these respective cases will drag the case. Eka 1 month. Not judge, adding the judgment bar. They will come and tell you, the accused will tell the court to say, you know what, I don't want to like my lawyer again, and that I am bringing you a new lawyer. And what that lawyer is going to say is that I am basing my application on that application that was granted when Atachia took over from Apia Kubi as a new lawyer who was given 6 weeks. So me too, right now, the accused has changed his lawyer. I am the new lawyer. I am also telling you, and court is all about basing on your statement of facts and evidence. All the lawyers are going to wait. So, Ochina, if this judge respectfully, this honorable judge says, oh, Atachia 6 weeks. All the criminal cases, we will never finish the cases. I'm telling you. All those cases, none of them will be concluded in Ghana. Because all that you need to do is that, as an accused person, get 4 lawyers on standby. Every time your case in echo close, no new lawyer, another one about you know what, I need to go back and look at the whole case again. So, with all due respect, my lord, give me 6 months. I need to go back because this case has been in court for 3 years. I have to go back from day one and analyze. Or koba wie na also 2 days my judgment about or say I don't want to work with this client again. Now another lawyer about. Can you stop them? No, because the precedents have been set. Because you, the judge, with all due respect, you created that room. You have created that hole, and all of them are going to use it. Let me tell you, when it comes to cases in court, you know the Gamanches case in court. When my case was in court, the smart lawyers of the Gamanche, basically, some of their argument in court was based on my case in the Supreme Court. Yeah, you know, go and read. Because no case is stupid case. So all these criminals, they are lawyers. They are sitting and they are waiting. They want this judge to open that window tomorrow. And you will see what will happen in Ghana. No criminal case will end in Ghana. Because if they are precedents, you cannot tell me you won't give me that. Why did you, the court? And at that point, they are not looking at you, the judge. They are looking at the court as a body. Until when you refuse to give them, they will go to Supreme Court. They will go to Appeals Court. Because why did you give Kevin Taylor you don't want to give me? And this is law. You cannot say that, oh, the last time the judge gave, I cannot give. No, the lawyers will say, me too, I am changing, I have been changed. You need to give the new judge, the new lawyer, that 6 months, 6 weeks, and it's going to be part of our legal framework. It is dangerous. The moment Atachia is granted this tomorrow, our legal system will break down. No criminal will enter jail. No criminal can be prosecuted. No judgment can be read in Ghana because now all that you do is you wait. Judgment bar. Eka 3 days. No change new lawyer. Who change new lawyer? New one bar. Or say please let's start from beginning. Okay, so on TS no. Let's go back. The precedent. It happened in 2026. Atachia took over from Apia Kubi and he was given 6 weeks. The same court. Why are you choosing today? Now I'm going to go to appeals court. I'm going to appeal that 6 months. So we need to be careful. And I believe that Ochinano, this judge, I don't know this judge, but I believe say or a one smart judge or wabutra or a very transparent. And the lawyer for Chairman Wontumi onim dia oye. Let's not create any room for these people to destroy our judiciary. Because Ochina, your boy whom is a mistake. Ne ka say, oh, Apia Kubi and a dema attaching go 2 weeks. Even 2 weeks is dangerous. 1 day is dangerous. I am telling you. Because all these criminal lawyers, all these lawyers defending these criminals in Ghana, they are waiting. Obuoha, or you said the next 6 months, the case, no, judgment beba or chain. Obuoha in the next 1 year, or you said the case, no, judgment beba. Obuoha, you said in the next few weeks, judgment beba. They are waiting. Tomorrow, if this judge grant Atachia this, no case will end in Ghana. I'm telling you. And you see why the MPP is doing this? They know that the MPP, they have an election. And NPP to conduct national executive elections between September 18th and 20th. Now, on the attachments up 6 weeks. 6 weeks, no, it will enter into August. Now, you can even say, oh, now said this one, August, this September, this is what they are trying to do. So we wait to free war. What is happening? And they say, the judiciary in Ghana, the Ghana judiciary's major annual break, the long vacation is about to happen. Officially takes place from August 1st through September 30th. Now, attachment was 6 weeks. It will enter August, eventually August 1st. Meaning, technically, there will be legal vacation. The legal vacation takes about August, September, about 3 months. Odianya is limited 2 months, meaning for the next 2 to 3 months, there will not be court. What is going to happen is, it means during this period, superior courts are generally on break, but selected courts, typically within the law court complex in Accra, are designated to sit on rotation to handle urgent and pending cases. When they say selected court, it could be that where Chairman Wontumi's case is not part of the selected courts, meaning Chairman Wontumi's case will never end. There are two things now attaching pushing this case to MPP primaries. Now Mutumbe chairman Wontumi, Omi chairman Wontumi, then the conversation would turn around. Kofi Benton and Kwasi Afoma now. Oh, you see, the national chairman of the MPP, Chairman Wontumi, is being persecuted. They want to print that message out. They want to create that impression that the NDC government, when they came into power, a criminal who was involved in illegal mining, where he was put before court with all evidence showing, hey, that guy is the national chairman of the MPP. So to them, it is not about the law being applied. To them, it's about using the law against us to protect their criminals. And the judge, given 3rd of July, the judge should not, even holiday also set it, not already judgment in the Ghana for. Because a mistake. They allow this judge, with all due respect to the judge, a mistake, not judge now allow this to happen. Atachia is not here. Atachia does not have any evidence to protect Chairman Wontumi. Atachia onim law papebia. Atachia is somebody coming in to delay the court, to disrespect the court, to frustrate the system. So what they want to do is they want to go for their conference or whatever quickly. In Tomukope, fast. Na yanyi Chairman Wontumi, because Chairman Wontumi, the guy I'm saying no, they share Bawumia campaign. We all know Chairman Wontumi works for Bawumia. And Bawumia is the one manipulating the party now. Ono na oshe so omunya no pam kere de Japan, because one na yire no person on the party ko ma charge for. Now what Bawumia is doing now and say monya nentam mama attach anko delay Chairman Wontumi case no court. Send e be betuma primaries no na delegate na be Chairman Wontumi. Send e be Chairman Wontumi ruling ne bana e bia etia na ne aka che wiase nyina say the national chairman of the NPP is being persecuted. But we all know Chairman Wontumi, what he has done, the reason why he's in court. Mamu Maya allowed the MPP to destroy everything. And I'll plead with the judge, with all due respect, Mr. Judge or Madam Judge, with all due respect, this is a very important case. Memenko Law School, so many people watching us, we have not been to law school. So far from the day this case started here, everybody has seen the transparency, the honesty of the case way. My interest is not to see Chairman Wontumi in jail. My interest is to make sure the right thing is done. Evidence, you write a judgment that nobody can contest. So I'm not here forcing anybody to jail Chairman Wontumi or let Chairman Wontumi go. My job here is to explain the process. If we are building, if we want to protect this nation, we need to do it right. Let's not allow some people, because of their political greediness, destroy the last pillar. Because the judiciary, basically, is the only thing that, at this point, some politicians are scared of. If we go tomorrow, we listen to Atachia, and we force Atachia, forces himself on us, lie to the court, and we basically swallow our own ruling and what the court is against. That is why I've read your own ruling to Ghanaians. And I know a judge like you with all the experience, say for once, and a nipa could be able to accuse you of anything. You have shown professionalism. Please, let's show this professionalism. Let your word be your word. Let your word be your word. And your word is that written submissions are optional. Written statements from lawyers does not affect judgment. In civil matters, a judge can mandate for that. In criminal matters, you said it clearly, nowhere in this world. And a written submission, a mandatory. So at this point, you have made us understand it is binding. Written submissions are not mandatory. You can go ahead and pronounce your judgment without even listening to Atachia. Atachia's post-court analysis, it's to his own benefit. It's his own opinion, and he can exercise it whether today or tomorrow. He has the right to do that. But the law, the court, only recognizes the evidence before you and the date you have put out. We will meet tomorrow. We will discuss Ghana. We will make it clear. Ochina, a year Attorney General being caught. Ochina, a year we will all monitor. And remember, you know one interesting thing? Atachia he's trying to lie again in court. He's the lawyer for Edubuahin. So, Madam Judge, Mr. Judge, you see what they are trying to do. If you listen to Atachia tomorrow, and you grant Atachia 6 weeks, 2 weeks, even 2 days, the same Atachia will go to court and cite this same ruling by you tomorrow, if that is where we are going to go. Because Atachia is a lawyer for Edubuahin. Edubuahin's case is close. They are about to end the case. If you give Atachia this, which you know, and you have said to us that it is not mandatory. So, because Atachia enco 6 weeks, enco written submission to judgment in Ma. Remember, Atachia is the lawyer for Edubuahin. And if you give Atachia this, when Edubuahin case ebedu and the judgment is about to be read, Atachia will step away, bring in Apia Kubi, and Apia Kubi will tell you that, do you remember this court? Because we are dealing with the court, not individuals. They will go to court and say, does the court remember that during Chairman Wontumi, Samra Boy criminal case, Atachia, who is now not Edubuahin's lawyer, contested that written submissions were important and that judgment was supposed to postpone. Do you understand? They will cite that. It will be the precedents they will be using. Atachia is setting 2 goalposts for himself. He wants to shoot without any goalkeeper in them. And that is what he will start from tomorrow. Let's not give them that. Especially when you, Mr. Judge, Madam Judge, you have made it clear that written submissions does not affect judgment of a case. Meaning, there is no case here for Atachia to make tomorrow. Meaning, Ochna, there is no case here. This guy is the same lawyer for Edubuahin. He will basically take Edubuahin to the final day and say, I'm no more his lawyer. Let Apia Kubi come take over, and Apia Kubi will cite Atachia's decision you are going to make tomorrow. So the best for us all as a nation, now that the law says it clearly, that written submissions in criminal cases are not mandatory, not important. Madam Judge, Mr. Judge, with all due respect, tomorrow, just quash this nonsense and then come out with your judgment on the 3rd of July. My name is Kevin Akoberutila. It's been a wonderful Sunday evening. Tomorrow, we will...
Abusua, we need ensema ekoso ewo political highway. So Chairman Wontumi ne lawyer and I see Samuel Atachia or Sheko mu na osre support no agene application no atuma mane. But I must say, some Japanese kokotisa and some way my gossip politics TV. So click on the notification bell so send any update be able drop also once a bit to me akabi medamase.